Hello students, this is a summary of Chapter 6, Dispute Resolution. It will follow my PowerPoint. So in Chapter 6, we study the structure of the court system and civil lawsuits. Litigation versus alternative dispute resolution, and litigation is a court case or suing in court versus alternative dispute resolution like mediation or arbitration. Litigation is the process of filing claims in court to go to trial before a judge or jury. Alternative dispute resolution is formal or informal process used to settle disputes without going to trial. The court systems, we talked about how federal courts serve the whole country. State courts, each state has its own state courts, and there's a diagram in the text on page 140 diagramming the court system. State trial courts, like in North Carolina, trial courts have a judge and a jury. They determine the facts of a dispute and apply the facts to the law and rely on earlier appellate court decisions. And there's an example in the PowerPoint, a fact scenario in the chapter introduction, applying the facts. If the court finds that Tony Caruso died accidentally, then Beth gets all the insurance money. If it finds that it was a suicide, then she gets nothing. Therefore, the outcome depends on the jury decided facts for that insurance claim. So take a look at that case. Jurisdiction is a court's power to hear a case. That's the definition of jurisdiction. A plaintiff may start a lawsuit only in a court that has jurisdiction to hear that type of case. Some courts have limited jurisdiction. Some have the power to hear almost any case. What is subject matter jurisdiction? It's a court that has the authority to hear that particular type of case. Trial courts of limited jurisdiction, courts may hear only certain types of cases. For example, small claims court only hears civil court cases up to, it says $5,000, but I think the limit has increased. Juvenile court cases, juvenile court only hears cases involving minors, right? Probate courts only hear cases involving the estate of a deceased. So these are type of limited jurisdiction courts. Family courts only hear family court cases. Trial courts of general jurisdiction, courts hear a broad range of cases. The general civil division, for example, contracts, employment cases, shareholders, derivative cases, state constitutional cases, negligence, torts. So those are types of cases heard in trial courts of general jurisdiction. What is personal jurisdiction? It's the court's authority to bind the defendant to a decision. So the legal authority to require the defendant to stand trial and pay judgments based on the decision of the court. Personal jurisdiction exists when the defendant is a resident of the state where the lawsuit is filed, the defendant takes formal steps to defend the lawsuit, a summons is served on the defendant, and if the defendant is a corporation, the long-arm statute applies where the registered agent is served with a summons and complaint. When the defendant corporation commits a tort, signs a contract, or conducts regular business in that state, that's when the defendant would be subject to personal jurisdiction by that state court. So you can read page 142, International Shoe versus the State of Washington. A summons is the court's written notice that a lawsuit has been filed against the defendant, and I've included in the PowerPoint a link as to where to find in North Carolina to fill out a summons and complaint if you were going to file a lawsuit. state appellate courts, we've talked about appellate courts. Appellate courts are higher courts that review the trial record of the original trial court to determine if the trial court made errors of law. If so, the appeals court may require a new trial, but they'll make a decision based on errors of law committed by the trial court. Did the judge give incorrect jury instructions, or did the judge allow evidence that they shouldn't have? Did they make a mistake as a matter of law? Appellant is the party filing the appeal. The appellee is the party opposing the appeal. We learned in trial court, the plaintiff is the person suing, the defendant is the person being sued, but in an appeal, the appellant is the party filing the appeal. It may be the plaintiff, it may be the defendant from the trial court, but in appeals court, the appellant is the person filing the appeal. The appellee is the party opposing the appeal. Both sides submit a brief on appeal, which are written arguments on the case. If the trial court made errors of law, the appellate court will reverse or nullify the decision. If the trial court acted correctly, the trial court decision will be affirmed or permitted to stand. Federal courts. Federal courts, as we know, because we studied the Constitution, are